great suit brought by Harmeet Dillon and Ron Coleman in California. You talk about having the receipts. They really have the receipts. Twitter, the state of California, conspired with the Democratic Party to conspire with Twitter to censor the people they don't like politically. And they have document after document after document showing it.
Who's the plaintiff in this case? Because for a second I thought it was Dr. Shiva, but it's not Dr. Shiva.
No, it's a guy that's in California that had a pretty big social media standing, a lawyer, as I recall, and he was completely barred simply for raising basic questions about what happened in the election. And some of the points he made were just basic questions. I mean, they weren't, even violations of Twitter's supposed rules at the time. So but what happened was it was someone who no complaints had ever been made about. Twitter taking no action against adversely. But the state of California created a special committee. This special committee gave private contracts to big Democratic consultants to flag Twitter items they didn't like in the name of election integrity. And they would go to Twitter, set up a special relationship with Twitter where Twitter would do whatever these Democratic consultants demanded, who were working at the behest and the behalf of the state of California. So you have clear, and they're also bringing back, I liked it, because it's the state of California, they're bringing back the Pruneyard Doctrine, trying to enforce it. This is a great case to test the Pruneyard Doctrine. The Pruneyard Doctrine is the one that says even private companies are subject to the First Amendment if they have a de facto monopoly on the public square. And clearly Twitter does in this space. But here they have even better, they also have additional evidence that that Twitter was acting as an agent of the state of California because they have the email path, they have the text records, they use variations of the Sunshine Laws in California, the same equivalent of the Freedom of Information Act, and they got incriminating information and admissions that showed the degree to which Twitter was just doing whatever the state of California through their Democratic political consultant, who was retained, by the way, effectively in a no-bid contract by the Attorney General, who gave him a sweetheart deal, who is now a United States Senator from California. So it's extraordinary corruption and collusion between big tech and the state and a now United States Senator to censor speech they didn't like concerning the election to protect and hide whatever bad acts they did during the election.
And not that, this relates to Shiva because this was what Shiva had been saying, but maybe, I don't know if it was better substantiated in the California.
Much better. I mean, nothing against Shiva. This is one very good skilled lawyers in terms of Harmeet Dillon and Ron Coleman. And I think the Center for Liberty, I think is what it's called, which also did a lot of good work for churches. And on top of that, great receipts. And on top of that, to be honest with you, a less controversial plaintiff. A plaintiff who who had no history of issues, no questions. His statements really aren't that controversial. And they can just show a direct correlation and causation in cleaner and easier and neater ways than any other case I've seen, other than Bobby Kennedy's case that's pending against Facebook. So this is extraordinary evidence that I think this case has as strong a possibility of moving forward as any case to put an end to this big tech government collusion to censor dissident speech.
From a practical purpose, how does any evidence or allegation or document adduced in that case, how can it be exploited or used by Dr. Shiva in his case? Can it, or is there no practical way of doing it?
Absolutely, it can be, and it can be in Bobby Kennedy's case. So, because again, these evidence just keeps mounting and mounting and mounting and mounting of big tech is basically been acting as an agent of the government, and that brings them within the First Amendment, even if nothing else purportedly does. Now, the Pruneyard Doctrine might also. This is a great case to test that in California and its vibrancy. But it's great at both of those. It's as clean a case as you could possibly have, as strong evidence as you could possibly have. So credit to Harmeet Dillon and Ron Coleman for really putting together a great case.
And can we just allow everyone out there in the interwebs and Ethernet to appreciate that all the time everyone's saying there's no collusion between big tech and the government. They're private companies. You lose that argument. You forfeit your right to that argument. And if you try to cling to it, it is as a result of either ignorance as to the newly disclosed facts or willful blindness as to those very same facts. It's undeniable and it's indisputable now. And so the only question is, will there be a legal loophole that would allow the defendants to weasel out on standing, on, whatever, immunity, whatever? We know as a matter of fact that there is active coordination. We've seen it now between Zuckerberg and Fauci with the news that could not be spoken. And You don't need to be a rocket scientist. In a year's time, we're going to see the same pattern with the election fortification discussion. We are now seeing it in real time. And anybody clinging to this with desperation to say that, no, there's no collusion between big tech and government, it's willful blindness or dishonesty, whichever one. But it's glorious. So you anticipate we're going to see the standard motions to dismiss, 230 immunity. I don't know, standing. I don't know if you can get that argument, but 230 immunity motions to dismiss.
Oh yeah, it'll be the same arguments they're making against Bobby Kennedy, which is, they'll try to pretend they're not really acting as an agent of the state, that it's not that degree of collusion for First Amendment culpability, that Pruneyard doctrine doesn't apply, that Section 230 immunizes it. You'll see all of those arguments, but they have the best factual and legal arguments to overcome that. And so we'll see. We'll see at the district court level. This is an appeal type case. It's a very good fact pattern for the Supreme Court potentially. So this case will be a precedent-setting case in the same respect that Bobby Kennedy's case is against Facebook.
I'm going to have to probably go do a dedicated vlog to this, but there was not enough time in the weekend. I got a fishing video out and a stand-up paddleboard video out. But other than that,